Hi, my name is Curtis Morrison. I'm an immigration attorney and founder of Ready to Law. Today, I'm going to talk about, this video is about our group lawsuit that we're going to offer regarding USCIS Policy Memo 602-0192 from December 2nd, as applied to pending I-765 applications. OPT also is included in this for you all out there. Okay, so we're offering a litigation opportunity for citizens of 19 countries listed in Presidential Proclamation 10949 to challenge the hold on processing and adjudication of their Form I-765 application for employment authorization, okay, that was implemented via the December 2nd policy memo. In sum, we believe the blanket withholding of USCIS processing and adjudications of I-765 applications is unlawful because it is based upon the national origin of the applicants and because USCIS lacks the legal authority to do such a blanket suspension or withholding. We will be filing 1 to 2 group lawsuits in 1 to 2 U.S. district courts pursuant to our discretion on the best legal strategy to accommodate the potential issues with venue and joinder. So, important dates to remember. January 9th, 2025 is the deadline to register to participate in this lawsuit. Okay, the filing date for the complaint. We plan to file this complaint or 2 complaints on January 16th, 2022. Shortly thereafter, we will file motions for preliminary injunction. So to participate in this group lawsuit project, I-765 applicant must meet the following requirements. Be an applicant inside the United States. The applicant must have an I-765 application pending. 3, the applicant must be a national of one of the countries impacted by the President's June 4th, 2025 travel ban. If you were impacted only by the later travel ban, we don't know if there's a USCIS policy affecting you yet, so you can't participate in this lawsuit. Okay, so 4, the applicant cannot be a plaintiff in other unreasonable delay mandamus lawsuits challenging delays related to their I-765 adjudication. Okay, so if you were a participant in our case that we just onboarded for your I-485, you could still participate in this case. I'm going to talk about that in a second. So the cost to participate. The attorney fee to participate as plaintiffs in this lawsuit will be $3,000 for each 765 applicant. This fee includes the cost of participation of all derivative beneficiaries who also have pending I-765s, okay, regardless of your family size. So the terms of payment are as follows. The initial fee of $1,000 is due in advance of the representation, okay, when you onboard. And the $2,000 balance is deferred and due on March 1st, 2026. The $2,000 back-end payment is only deferred as a courtesy for like the unpredicted hardship that is faced by the victims of the December 2nd, 2025 USCIS policy. Participants who are not comfortable with this contingency of the deferred payment, they're welcome to prepay the entire $3,000 attorney fees. Okay. So there's an exception to our pricing here. If you participated as a plaintiff in what we call PM-613, or group lawsuits for 485 applicants, the participation as a plaintiff in this lawsuit too is only $1,000 more with no deferred or back-end payment. So onboarding for this lawsuit is automated on our website. You can go to our website. It's up on the bar on the very top. And I appreciate you considering us to represent you at this very difficult time. And if you hire us, I promise you that we will work for you and do everything we can to get you the benefits that you deserve. Thank you for watching this video.